I'm Neil Taylor, Director of the Corporate Law Center at the University of Cincinnati College of Law, and welcome to the Corporate Law Lab, the podcast exploring corporate law themes of interest to law students and practitioners. This week, our guest is Darryl Kates, recently retired as Executive Labor and Employment Counsel at GE Aerospace. Darryl and I worked together in law school, and I am guilty of regularly squatting in his office when he was the lead articles chair of the Law Review. We had a great conversation, and Darryl had a ton of useful and practical advice for our students, in-house counsel, and lawyers who work with in-house counsel. A quick note on the audio quality near the end of the episode. One of our students asked a question that is difficult to hear. We left it in because the question becomes obvious from Darryl's answer, but we'll work on making sure that doesn't happen again. I hope you enjoy the episode half as much as I enjoyed catching up with Darryl. Welcome to the podcast, Darryl. We'll get started here. We knew each other a long time ago, for a fair amount of time. We graduated from UC at the same time. So let's go from there and talk about, what was your first job out of law school?
So I worked at a firm in Canton, Ohio, about a 40 person firm in a very small town in Ohio. So they were kind of a big fish in a small pond. Worked there for about 4 years as an associate, and turned out to be a wonderful experience. You get a wide range of things that you get to see. I second chaired a medical malpractice trial, got to second chair a discrimination case, involved in a union strike, got to help with some trust and estate work. So you get to give you a good feel for what you might like to do lifelong practice.
Well, and I think that's one of the things about being in a smaller firm that people don't realize is that there's quite a bit of opportunity for the young lawyers there. I mean, it's not as much money, obviously, but you get to do things that you might not have had exposure to if you had been, gone to New York and spent 3 years third chairing depositions,
And I think that's right. And I thought I knew what I wanted to do coming out of law school, but having the experience to actually see it in practice was incredibly helpful.
So what did you think you wanted to do coming out?
I thought I wanted to do litigation work, and saw some of the labor and employment work, the arbitration work that happens, the union contract negotiations, and really just kind of fell in love with that and thought, this is where I want to be.
Did you take all the labor classes in law school?
Professor Murphy. Yes, it was wonderful. And it turned out that his daughter actually she clerked for our firm in Canton, Ohio when we were up there.
Wow.
Jane Timken is her name, and she's the head of the Republican Party in Ohio, by the way.
No comment.
No comment. I know that would be dear to your heart.
And we were together on the UC Law Review. You were the lead articles chair, if I recall correctly. What was that experience like? And did it have any spillover effects into your career?
Well, first, it was great because at that time you had an office as the lead articles chair. It would have been even better had I got to use it, but you were typically in it, so that was not great. But yeah, the nice part about being the lead articles chair is you got to work with a lot of outside professors, and it gave you a good feel for some of the published work that was happening and some of the innovative thought that was taking place. So that was actually, I really enjoyed the role.
Does it still seem odd to you in retrospect, the way law reviews work, that the students are judging the professor's work?
Yes. To have us edit their papers was a little different.
And we would have to get up to speed on things we knew almost nothing about and decide whether or not it was a go or no go on publication.
Right.
You also had to manage fights between me and the other lead articles editor over what to publish and not publish.
Which also turned out to be a helpful experience.
I'll bet. I still haven't given up. I still think I was right about that.
I'm sure you were.
So what are you doing now?
So I retired a couple months ago. Prior to retiring, I was the Labor and Employment Counsel at GE Aerospace. GE Aerospace is now a separately traded public company, but for many, many years it was a division of General Electric. It's the world's largest manufacturer of jet engines, and it's headquartered here in Cincinnati, Ohio.
So I didn't even realize it was a completely separate company now.
Yeah, we broke up GE into three separate companies about a year ago.
Okay. That must have been an interesting time.
It was an amazing time. Yes.
So we skipped over, obviously, you don't go direct from 40 lawyer firm in Canton to head of labor and employment at GE Aerospace in a heartbeat. What happened in between those two things?
I spent about 4 years in Canton, Ohio, at that law firm, and my wife and I had a child. We grew up in Cincinnati. A role came open at Dinsmore and Shoal in their labor and employment group, and I moved to that role, and I worked about 4 years at Dinsmore and Shoal. Um, and then I moved into General Electric, having done some work for them at Dinsmore. So when their role came open, I applied and worked out.
Okay, John, I'm going to let you take the next couple of questions. This John Zhu, right?
Yes, you're correct. So, Mr. Case, thank you for coming with us today. So I think my question starts with your decision to become a corporate counsel. So how did you make the decision?
At the time, I'd been practicing about 8 years and about 3, 4 years at Dinsmore. So I was right at the point where you're either going to be a partner or you're probably going to leave. And I was in good shape to be a partner. So I kind of looked at three different factors. One is the money aspect of it. On that side of it, I felt like if I would have stayed at Dinsmore and had been able to land big clients, get a big book of business, I would have made more money at Dinsmore. The money at G was fine. The other piece of it is, are you going to like the work that you do, what you have to do? When I looked at being a partner, a lot of it was going to be getting those big clients, a lot of marketing, a lot of selling wasn't really in my wheelhouse. So, and I had done some work at GE, and I loved the sophisticated work that they were doing. They were, 200,000 employees at the time, so you saw everything. So I really felt like that was going to be a great spot for me that way. And then the next part is, how is it going to impact your family if you make a change? And at the time, probably incorrectly, I thought I go in-house, maybe I work fewer hours, maybe it's a little less stressful, and it'll be a better role for me. So ultimately, I decided to go in-house to GE for those reasons.
Well, thank you. I think these are all very good points. So my second question would be, what factors influence your decision on that?
So, I think those were a lot of the factors. Some of the assumptions that I made, some of them turned out to be right, some of them turned out to be wrong. One of the big selling points was that turned out to be correct is you don't have to track your time as an in-house counsel. So the idea of having a billable hour requirement and having to track your time in 10-minute intervals, that was wonderful to get rid of. To be able to focus on the end product and not how much time you're spending on it was great. The thing that didn't really pan out was I don't think I spent less time working, moving in-house. What ended up happening when you move in-house, whether you work 40 hours or 100 hours in a week, your time is paid for the same. You get the same amount of salary. So you actually your time becomes free to the client. And so they pull you in on a lot of things you may not need to be pulled in on. So you end up working a lot of hours until you build up enough credibility and enough knowledge of the business to say, you know what, I don't need to be in that meeting. You don't need me for this. So I wound up putting in a lot of time.
So when you get to that point, how far into your career were you when you were able to say, no, thank you,
that meeting doesn't seem to be one that requires a lawyer.
You know, it wasn't a matter of months. It was more a matter of years. It was, probably 3 or 4 years before you built up enough faith and credibility to say, you know what, I'm just, you go do that.
Well, there's also knowledge of the business. I mean,
That's exactly.
in my first foray into being in-house counsel, I knew nothing about what we did for the first year, it seemed like. And I was managing litigation, and I'm sure were you managing
Yes.
outside
Yeah,
litigation?
yes.
So everything you're doing is out the rearview mirror.
Yeah.
With all that said, how do you go about learning the business to be able to feel like you're adding value?
So I did a few things at GE. So one of the things that I did that I found incredibly enjoyable was learning about jet engines. So I took a jet engines basic class. So every Wednesday night, I would spend a couple hours learning about how jet engines work, which was fascinating to me. The other thing that when I would travel to a plant for an arbitration or a mediation, I would always ask for a tour to see, okay, how are we making these particular parts? How are we assembling these engines? And you'd see things like the 3D manufacturing that we did, and some of the technology that goes into these engines. Again, very useful to learn the business. And then the last part is just learning, I'll say, the industry and how the company makes money. So I made a concerted effort to get to know the finance people and some of the marketing people, because that's really where you learn the industry and how the business makes money. And a lot of times it surprises you. Like, for example, with our business, the aerospace, we don't make a tremendous amount of money when we sell a new engine. Sometimes very, very little. But what happens is if you get the engine on the plane, they come to you for the spare parts and the service, and that's where you make the money. So you learn it's kind of a printer and ink kind of situation. So you learn that aspect of it, and then you learn that, look, for some of the people that are, there are some companies out there that are both customers to us, they're competitors, and then we have JVs with them. So you have to learn the industry to know that.
So how long did you feel like that took to get a handle on, I think I understand what these people are doing here and how I can add to it?
I think it's an ongoing process. You've got to, because the business does change and who's running the businesses change. So you got to stay on top of it, but a couple of years to really get a grasp.
Did you feel like people understood why you were there and what you were there to do? Or did you have to kind of market yourself internally as, here's what I'm here for and here's what I can do?
I was very fortunate to have a boss who had been there for 35 years as the head of the Labor and Employment Group. So he was very well known through all the senior executives, and having a kind of a niche labor and employment expertise, it was very easy to get incorporated into the business, into the HR function, which was our primary client.
It's interesting. In my experience, we had titles like, Associate General Counsel and Deputy General Counsel, none of which the business understood at all.
Yeah.
And we actually ended up giving ourselves titles later. So if you asked me what my title was, I would say Senior Vice President and Deputy General Counsel, because the business understood what a Senior Vice President was. They had no idea what a Deputy General Counsel was. I mean, and that was, and again, I was lucky that I had a boss who had been there forever and was very well respected. So if nothing else, I would, say I was sent here by David.
Yeah, that also helps. It was actually easy with the HR function. It was less a problem of getting them to pull us in, and it was more of a problem as they would pull you in more than they needed to, because it was very nice for them to say, well, I ran it by legal, and also you've got a lot of experience, right? So you've been there, seen a lot of what some of the younger HR people may not have seen. So it's helpful for them to have you at the table or helping with the decision making.
There's the old trope about legal department being places where ideas go to die. How did you avoid that?
I think it takes a while to be honest. You can't just be the person that says, no, you can't do that. You got to help the business leaders, the HR function, get to the best solution, and you've got to ask questions to say, okay, what's the end game here? What do we need at the end? And once you know the end game, and it helps to know the business in order to understand that, you can kind of get them to where they need to be. It may not be how they wanted to get there. It may take a little longer, but eventually you can get there.
Yeah, I think that's really important that you highlight that so often I would say to a client that said, I want to do this.
Yeah.
I would say, tell me what your end goal is, right? I understand what you want to do today. And without saying to them, you're not going to be doing that, I would say, tell me what your end goal is, and then let's have a conversation. And then I, help them. Sometimes their end goal was clearly something they were never going to do.
Yeah.
But more often than not, it was me helping them come up with a path to get to where they wanted to be.
It's also about explaining risk, right? What is the risk of the decision that you're making, and helping them understand, okay, here's the risk, and it can be very bad if it happens, but it's not likely to happen. So, helping them understand what the risk is of the decision making, and then like guiding them to reduce that risk.
Did you ever have problems with clients who either went rogue or wanted to? I don't care what you say, but that person, I don't want them back in my division office.
You get some of that. You get it the other side too. So with respect to labor and employment, for example, you're reviewing potential termination cases. So you'll get somebody that has committed, they've made a mistake, or they've committed some kind of breach of policy. And normally you would fire the person for that particular breach of policy, let's say. But you've got a manager who's got to deliver for the customer. And the person that you think should be fired, maybe they're critical, or maybe that manager's been working with them for 15, 20 years. Their kids play soccer together. They don't want to fire this person. In those situations, what you may have to do is raise it up to, the manager's manager. You don't do that behind their back. You tell them, what we need to talk to so-and-so about this beforehand. But you may have to raise it up, because at the end of the day, that manager is not really your client. It's the business that's your client, and you've got to help make sure the business is doing what's right for the business.
Is that something you had to explain directly to people? I'm not your lawyer, I'm the company's lawyer, or is that something that, how did you approach that?
So on some rare occasions, most of the time people understood it. There have been some rare occasions with some senior executives that you do have to have that conversation. And sometimes what you would do is you would pull an outside counsel, and then it becomes very clear that the outside counsel are representing the company.
I'm curious, when you said you'd done some work for GE before you joined the company, how much was the inside of the company different than what you expected it to be from your outside view?
So there was a lot for me still to learn when I came in. I think probably the hardest thing for outside counsel to adjust to when they move in-house is the way the work gets done. If you're outside counsel, you are the expert. You are the person that we need you to give us the right answer. When you're inside counsel, I won't say you do. You tend not to go as deep into matters that you don't need to go deep into. So, for example, your day may be you have to deal with an employment discrimination case. The next thing up is a union contract negotiation. The next thing up is maybe an OFCCP or affirmative action audit. In a law firm, a different attorney is dealing with each of those different matters. You're handling each of them, trying to assess risk, trying to give the business the best advice you can. It's a little bit of a triage role at times. And I think that's hard for outside counsel to adjust to because they tend to want to go deep in each one of those areas and make sure they have the complete, exact, all the facts, all the law. You're just not going to get that a lot of times with being in-house. So you have to be able to get comfortable doing triage.
How did your former colleagues react to you being in-house? Did they view it as, oh, thank goodness Darryl is there now, here comes the bonanza, or?
So there was there was a lot of that. So you do get that feeling, okay, now I've got a contact at a really big Fortune 500 company. This is going to be great. They're going to come back. And frankly, I did go back to them for it. But honestly, there were times when you might get taken advantage of in that respect. Well, Darryl knows what he's doing. We put the associate, the first or second year associate on it. Darryl will fix whatever work product is. I did not want to be the partner on the litigation. I wanted the partner to.
You were hiring outside counsel for a reason.
Right.
Yeah.
So there were moments when that had to be fixed.
Did you ever have them pitch you work that you knew the lawyer pitching it wasn't up to it?
Yeah, absolutely.
How did you handle that?
I think you got to be honest and just be blunt. I think you get pitched a lot in these roles. When I came on board with GE obviously had a preferred provider group of lawyers that we went to and that the company already used. And what's interesting is you get to see the different levels of performance from some of these really good law firms and some that, not so great work. And you really start to be able to distinguish, okay, this is A+ type work. And what I was seeing might have been B-, B+.
Yeah, I remember having a conversation where I went to the managing partner and said, you need to have that person pitch someone other than me, because as you know, I know that person.
Yeah.
and enough said, right?
I think that's the other thing that I learned just being in-house and seeing the different lawyers is you get a lot of boutique law firms that, maybe do labor and employment practice all over the country, even internationally. The problem is one office, maybe the Los Angeles office is spectacular lawyers, one person there, but you get to the Boston office and you go, right? So
Right.
what you end up doing is, my approach was I like to hire lawyers and not firms. So, and like you say, in your law firm, you would see that there were some that were really great at what they did and some, I'd rather not.
So in the selecting outside counsel, so for all the outside counsel out there listening, here it comes. What was important to you? Did you run beauty contests? And I know maybe beauty contests is the thing we need to stop saying, but what it meant was, bringing in 3 or 4 firms and letting them pitch the work, or did you do it through referral? I mean, I guess it's probably all of the above.
Over
right?
the 25 years, it ebbed and flowed, and you would use all different kinds. There was one point in time we ran an auction process. We would pick out 3 or 4 firms that we knew were very good and say, okay, at noon, we're going to have an auction for this matter beyond. And we ran an auction to see who would come in the lowest.
So at that point, you had already pre-vetted
We
that
had pre-vetted.
any
Yes,
one of these people can do this work
that's right.
at a
And here's
level that we're happy with. Now it comes down to price
the money, and we would do an auction.
and a flat fee deal.
Yes, and the process worked okay sometimes, but honestly, we ended up not doing that for long because you end up getting lower prices, and the quality of work wasn't what we wanted.
We had a conversation last week with a lawyer from L'Oreal in Paris, and when we were talking about this very thing, she said, every time I've tried a flat fee deal, I ended up regretting it at the end of the day, and that was my experience too. Why do you think that is?
I think it's because they up front they want the work, so they're kind of lowballing the offer, right? They're lowballing their budget, and inevitably, it costs more for them um, to do the work. So, but from my perspective on an in-house, I've got a budget I've got to hit. Whether that's for that individual matter or for the year, I've got a budget, and predictability is really important. So I can't go to the finance leader and say, I told you this was going to cost about 100,000. It actually came in at 2. I can't have that message. So if I love to negotiate caps with law firms. So look, we pay you an hourly rate up to a cap, and that seemed to work pretty well. If things blew up for unexpected reasons, we could talk about it.
You had to have a level of trust with each other that you weren't going to let them twist in the wind if things
That's
came
exactly
out.
right. And if we settle it the next day, it's the hourly rate.
Right.
Typically. So yeah, so you asked about the other things we look for. I think low cost, but more importantly, or as equally importantly, is predictability. And the cost was key for me. Responsiveness. I don't want to have to chase the lawyer. I had a senior partner up when I worked in Canton tell me, he said, you know what? Most of the clients you have are not going to know whether you're producing an A-level brief or a C-level brief, but they are going to know whether or not you're returning their phone calls promptly and whether they have to chase you and run to find out what their matter is. So take care of that first and make sure you're doing good legal work. But the key is, if you want to keep clients, you've got to be responsive. So I did look for responsiveness. In the labor and
I don't think you can underestimate how important that is when you're in-house counsel. And we used to joke that we could, and we were joking, that we could do nothing for 3 weeks as long as we called everybody at the end of every day and said, didn't get you to today, but tomorrow might be your day.
That's right.
Because as long as they knew that you were out there and that you knew that,
Right.
You needed to do something. And of course, we never took advantage of it, but you couldn't just let people wait and wonder.
That's right. That's exactly right.
So.
In the labor and employment world, the other thing that's really important, summary judgment is kind of the key, right? If you lose summary judgment in a discrimination matter, the value of the plaintiff's case goes up quite a bit, right? Because they're going to get to a jury. So I looked for people that good writers, somebody who could write a persuasive, succinct brief. It also helped me in my day-to-day job if the person was a good writer that would prepare something summarizing the case and the risk of it that I could just flip to a manager who's wanting to know an update versus me getting a 5-page memo with a bunch of hedging and having to basically rewrite it to something the manager's actually going to read.
That was my pet peeve with outside counsel, is the ones that told me there was a 50-50 chance of something happening. I just feel like I have a coin. I can flip a coin myself. How much, when you first left private practice and went in-house, how much deference did you have for outside counsel and, what they were going through, what they were doing, and did that change over time?
Yeah, I think it probably had quite a bit of deference when I first left, just because I'm working with people who had been practicing 30 years, and I'm now 8, so you're relying on them a lot. As you gain experience and you see the different law firms and how they work and the different levels of expertise, you end up being to evaluate, well, that's an A brief and that's an A- brief. You learn what's good, what's okay. And you end up showing, I think, less deference to them. There is still that element of it's a partnership, right? So you do want them. I understand they've got to make money. So you do want to work together.
Yeah, I think I was always, well aware that they needed to make money and that we needed to be fair to each other. And, the worst fights were always going back to your unexpected, when you've taken a matter to trial and you've got a budget of 300,000. I mean, the worst one I ever had was something like that, where the budget was, a substantial amount of money. We won the case.
Right.
And it was 2x, and we never worked with that firm again. No matter how great they were at bringing home that jury verdict, we couldn't work with that firm again because everyone thought we were crazy for spending that much money.
Yeah, it is tough. And I actually have a lot of sympathy for it because I was not great at preparing budgets. It's a hard thing to do.
Well, yeah, budgeting for future litigation. How did you go about that?
So, in-house, you look at past practice, right? It's how much did we spend last go round? And then you look matter by matter and say, okay, do we think this is going to blow up this year? Or do we not think it's going to blow up this year? It is a really difficult practice because you're doing this budgeting in October for the year before. There are people that are going to get fired in January that are going to sue you in February or March that you know nothing about. So you've got to factor in a little bit of money for those kinds of cases as well. And then what will happen is it'll get cut 10 to 20% by leadership after that.
I remember an argument with the CFO one year where he looked at my litigation budget and said, it's too high. And I said, okay, put down whatever you want. And he said, no, I want it to be right. And I'm like, okay, then you have my number. And he said, but it's too high. And I said, put down whatever you want. And we went like that for 10 minutes before he finally threw up his hands. Because I was always wrong. And the thing was, his budget was always wrong. It had to be.
Yeah.
Anybody that hits their budget exactly has done some kind of
probably was scheduled to come in under and spent more than so they didn't get dinged next year. Yeah. So it's tough, but you do the best you can with it.
Yeah, we actually, in the computer business we were in, we'd had our biggest week every year, the last week of the year, because people were out there spending their budgets.
That's right.
So speaking of, I mentioned computer outsourcing. Talk about how technology was used when you started practicing and how that changed over time. I assume that it did.
It did. So you and I just did a little tour of the building, and we were joking about the fact that the library looks quite a bit different than when we were in school. The technology piece has changed dramatically over time.
Yeah, I mean, I had to take you into the basement to find the books.
Book. Yeah.
Right.
Yes. So you really, it's gone from, the practice has gone from, sitting turned to your phone to sitting, in front of a computer screen. So the one thing that COVID did that I found, it made audio meetings so much smoother. I rarely left my office after COVID because you don't go down the hall to the meeting. You just, everybody comes, joins the audio of this, meeting, and you're there, which was honestly pretty helpful.
How much did you have, though? Were they really there?
Some of that, right? There's some of that, and I am guilty of it myself, where I wasn't completely there all the time. But if you're on camera, which was something we always tried to do, that helped a lot.
Yeah, cameras on was
Yes.
key to.
The one thing that did kind of annoy me a little bit with the videos in outside counsel you mentioned, I wanted them to have not a t-shirt on. If they're going to be talking to my leadership, I needed them to look like a lawyer that I was paying $600 an hour to. And sometimes they would show up in sweatshirts, and I have to make a little comment. But yeah.
Yeah. Well, those things, I have no comment. I was joking with you before that, since I got this job, I'm mostly dressing like an adult again. But so You talked before about triage and seeing cases, the summary judgment motion was the key. But you must have decided earlier than that whether or not this was a fight you wanted to get into, right?
Yeah. So what typically happens in the the employment discrimination world is that, let's say you'll lay off or you'll fire or you'll discipline an employee. You'll then get a letter from their counsel saying, okay, I think this may be age discrimination because of X reasons. Can you provide me this information? And we'd like to talk. That gives you that opportunity to evaluate the case, say, okay, this is maybe one that if we can get rid of it early, we ought to engage in the conversation and get rid of it early. If that breaks down and fails, what will then happen is you'll likely get a charge of discrimination followed by a lawsuit. One of the things we had at GE, which was helpful, although it did not apply Title VII, which is race and gender, we didn't apply it to that, was an ADR program, so alternative dispute resolution program, that if an employee had an issue with how they were being treated or how they had been treated, they could go through the program, have a sit-down meeting for the first step with their manager. If they didn't like the response, they could talk to the manager's boss and have a meeting. And then if they didn't like that response, the next step was mediation. And that's when the lawyers would get involved at the mediation stage. And that would also give you that opportunity to get rid of those cases that you thought, well, maybe we've got some risk here and we should try to.
I don't know that we're going to lose, but I also don't know that we're going to win, right?
Right.
Yeah.
Right. And regardless of what happens, we're going to spend $100,000 fighting. So.
And you were partnered with the HR department. I mean, I had a similar role at one point. And how did you maintain a level of, I guess, objectivity, I guess is the word I'm looking for, when it's your friend's work in the department down the hall that you are essentially evaluating when deciding whether or not we need to settle a case?
And one of the challenges with being an in-house counsel is you're in the room a lot of times when the decisions are made, and maybe you were in the room when the decision was made to terminate the employee or to take whatever discipline there was. And now you've got to go back to the client and say, I think we should settle. Right. So it's a challenge, but I think sophisticated business people understand that there are levels of risk with taking certain decisions. And you walk them through those levels, the risk up front when you make the initial decision. And if it turns out that you have to pay money to eliminate that risk, then maybe you do pay money.
I don't know if it was the case in your business. I mean, I was in tech and it was extremely cyclical. So we had for the younger people here, there was a tech bubble and it burst in 2001. And, my company went from 15,000 employees to 8 in the course of a year. Not 8 employees, 8,000. And the speed of decision making was such that there were lots of opportunities for mistakes. I don't know if you had similar experiences.
So you can imagine during the COVID experience when your product is jet aircraft engines and nobody is flying, nobody's traveling anywhere. So we laid off about a little over a fourth of our workforce within a 8-month period. Those are tough just from an emotional standpoint, because the other part being in-house counsel is the people that are getting laid off, you know them. They've served as witness for you. You know their kids. You've worked with them, and that's hard. The upside a little bit, yes, there's a lot of speed in the decision making, but if you're one of thousands that are being let go, there's kind of an explanation, right? Nobody's flying. We can't afford to have this many people working. There's just not work. So from the legal risk standpoint, it's actually maybe a little less when you have those catastrophic events.
At that point, you're looking more in terms of categories and
That's right.
I mean, I would literally run statistics and say, out of our population, how many people in these categories, these protected categories, are being laid off compared to, because you are going to lose the case if you lay off every person over 40,
Yeah.
even though objectively in reality those were the right people. Almost certainly they weren't if you
That's
did
right.
something like that. But that's what you run into
Yeah.
and it's a much different job than evaluating what did
An
Darryl
individual,
do,
right.
and does Darryl
That's
still work here after this?
That's right. And we would do the same thing. I think most companies will look you look at like 2 standard deviations is generally what you look for. Anything over that, you take a closer look at.
Which meant that at some point you had to learn what a standard deviation
You
was.
did, yes. That would be the extent of my math.
Um, Talking a little bit more about outside counsel, what, like you talked about, you had a number of very high level firms, probably names that everyone would recognize. What could they do to stand out?
So I mentioned the predictability of cost. So from that perspective, we would do things along the lines of, like, one firm we got and created a hotline. So when we were resource strained, we created a hotline that allowed HR people to go directly to this law firm. And they had assigned 3 different partners or people for each division to call. And the advantage of that was that this was a national firm. So if you had a wage hour issue in California, they had a California wage hour expert that you could call. And we would pay a monthly retainer for that ability to do that. And they kept track of their time, so they would consistently come back and say, "Hey, you guys are calling a lot." And then we would try to
I think,
do that.
we were talking earlier about flat fee deals. For me, the thing that makes flat fee deals the hardest is that the law firms will keeping score the old way.
Yeah.
I mean, I don't know how many times I had people call me up and say, after however long we'd been doing it, say, this isn't really working for us. We're putting more hours into this than we expected. And it'd be like, okay, but you weren't calling on the other flat fee deal we did. That one must be working badly for me, is it?
Yeah, that's exactly right. And there's a little bit of this is a way for them to get additional work that does make them profit. So if they dealt with the issue up front, more likely that if we do get to litigation, or if we do have the charge that we need outside counsel to help us with, good chance we're going to them to deal with it. So it can be kind of a lost leader for them a little bit.
Or at least something where they should be playing the long game and
Right.
think about the
Exactly.
relationship rather than
Right.
just, oh no, I've billed 100 hours inside my firm and times X times Y is not adding up to what it should
That's right.
if I was billing my full hourly rate.
That's right.
So on the other side, what did they do to make you say, I don't want to use them anymore? I'm going to find either a different lawyer in that firm, or it's so bad that I'm going to a different firm.
It happens. There's no that's happened quite a bit, and the reasons are varied. I've had cases. One of the more interesting ones, we do these mock juries. So if you lose summary judgment, you're going to trial. What we will do sometimes is we'll get a mock jury together where we hire a consultant, bring people in from off the street, temporary workers, and we present the case to them. And we have somebody else present the plaintiff's case to them. And we stand behind a 2-way mirror and watch the jury deliberate and see what works and what doesn't work. One of the times we had that, I just thought the presentation of the cases was so bad that we needed to make a change, which is a late time to make a change. But that's one example. I mean, the other things that happen, whenever you hire outside counsel, it's a reflection of you. If you put them in front of senior leadership and they aren't prepared and they don't do well and you're not going to use them again, right? Because your business leaders are looking at you saying, okay, that's what we got.
Yeah. Even if you luck into a result.
Even if you get a good result, right? Exactly.
Did you participate in witness prep?
Yeah, I tried to, absolutely. I think from an employment discrimination case, the two key factors are, one, making sure your managers are ready prior to their deposition, and then the plaintiff's deposition, making sure that they take a good, making sure we take a good plaintiff's deposition so that we can get ourselves ready for summary judgment. I think participating in our witnesses prep is really helpful from a couple standpoints. One, it helps me evaluate the case because I can evaluate how well I think the witness is going to do. And two, if you really know the business, a lot of times the business leader or the manager will talk in terms of acronyms and things. You can be there to help translate the business for that outside counsel. So I think it's helpful to participate in witness prep.
Yeah, I think it's, I often referred to myself as a translator.
Yeah.
I would say to the business, I speak legal, I can tell you what those guys and ladies are thinking. And to the lawyers, understood the language of the business. We had TLAs everywhere, 3-letter acronyms.
Yeah. Right.
And we had a TLA for TLAs, leave them. And to get them to actually talk, I think it also let them feel like you were not throwing them to the wolves.
Yeah.
That you were part of it. I think from outside, people look at that situation, and I've certainly seen it at trial where somebody puts John on the stand and says, John, when you prepared for this case, how long did you meet with X?
Yeah.
They couldn't get into the attorney-client privilege communication, but they could get into the fact that it occurred. And they would say, and was Mr. Taylor there? Yes, he was there the whole time. And they would try to imply to the jury that I'm standing on his head, keeping him from telling the truth, which couldn't have been further from the truth.
I always felt that risk was outweighed by the benefit of being there.
Yeah, I agree with you completely. I think if I had felt that there was some criminal exposure in whatever was going on, that's the time when I would be like, I'm out of here, not because I didn't want to be in the heat,
Right.
it was because at that point I'm risking it looking like obstruction. Right. That's the time when I go away and say, here, Mr. Outside Counsel,
Generally, when those kind of risks, your outside counsel is all over. Yeah.
Yeah. And telling you to stay out of it.
Yeah, exactly. I think that's right.
Yeah. So we've been going for a while now, believe it or not. I know it feels like we're 10 minutes into the conversation, but we're actually 45. If you had to, I've got a couple of closing questions. If you had to sum up your role as in-house counsel, what would you say are the most important things, and what do you think people perceive that you do that you really don't?
So my role is I think it is the advice and counsel piece. I think you've got as in-house counsel, I think you've got to remember that you're not the decision maker. Right? You can't have a situation where the manager takes the stand and asks, "Why did you do that?" Well, legal told me to do it. Right? That can't be the answer. So I think you've got to keep that in mind, and you've got to keep in mind that the client is not the manager. The client is ultimately the company. So if you feel like something is wrong and a bad decision is being made, it's incumbent upon you to keep raising it up until it gets to a level of, in some cases, the board, if the risk is high enough. So my role, I viewed as advice and counsel to the business, to the corporation, which sometimes conflicted with being giving counsel to the manager, because it was sometimes they didn't want to hear it.
And then on the perception that people thought you were doing that you really weren't. I'll tell you what mine is.
Go ahead.
They thought I was an encyclopedia who had gone off and memorized all the laws applicable to our business, and that they could, if they pressed button A7, I would play that tune.
Yeah.
And,
There is probably a little bit of that as far as overestimating, because we were, an international business. So we had, plants all over the world, and it's hard enough to try to keep up with the laws of the various states, much less trying to keep up with the laws of the different countries. So thinking that you're going to have a quick answer on some of these questions, it's just not going to happen. So there was a little misperception of that, but you shouldn't.
Last question, maybe depends on what your answer is. If you were back in the old dark building we inhabited as law students, what would you like to tell the 33 years ago Darryl Kates that he should be concerned about or not concerned about?
Oh, wow. That wasn't on the list.
I know.
We talked about it a little bit before with the different career paths that people take, and there were clearly a lot of, you get to the point of having what I think I've had a very fortunate career. If you would have said, this is where you're going to end up, back in 1991, I don't think I would have predicted, staying with one company for 25 plus years. It just worked out that way. What would I tell myself? I think it's to cut yourself a break, to be patient and just focus on doing good work, continue to do work, have the confidence that it will work out. And it does. I probably stressed more than I should have stressed over things that didn't help me.
Yeah, I think I would. I completely agree with that. Like I was saying, I have a lot of people say to me, we'll see if they keep saying it now that I've found my way back full circle back to UC. I want to do what you've done. How do I do that? And I'm like, well, there's 11 mistakes you'd have to make.
Yeah, that's exactly right.
and
Yes.
that will
At the time, just right.
yeah, you got to time them just right, and they can't be catastrophic, right? But and there's 50 different things that you have to be in the right place at the right time, and if you weren't, something else would have happened that probably would have also been okay.
That's right. Yeah, you talk about career-wise, and I mentioned, sometimes with managers, you have to go above their head. With GE, I will tell you that it was almost non-existent that I felt like people weren't wanting to do the right thing. It really never came down to that with, you have to, I mentioned going to the board. I never had to go to the board for anything that I felt like the managers were doing something that was improper. So I do think generally the people, they want to do the right thing.
Yeah, I think my experience too was that even the people that found themselves in trouble for some reason was generally a slippery slope, or trying to do, they took a shortcut that led them down the wrong path, and once they were on that path, they couldn't figure out how to get off of it.
Yeah, I mean, you deal with misconduct, but the leadership that you generally get to, the right decision ends up getting made if you take it to the right level.
Okay. Any questions from the others in the room?
I have another question that was about the lawyers. You told us before that you usually hire lawyers. And I wanted to ask you if there are certain roles that are like always present, like someone specialized in the marketing area, privacy and data. It's out of the book maybe, but
No.
just to understand how does the team of lawyers work?
It's
There is a team or
Yep. So when I worked at GE, I did the aerospace division and I did labor and employment work. So what was encompassed in that were 2 to 3, depending on the time period, US-based lawyers that would do discrimination, union work, those types of things. And then we would have, I had 2 European lawyers, one in Italy, one in the UK, and another in Asia that would do similar work. They would handle the labor and employment work. The carve-outs, we were big enough that we had a privacy lawyer that just focused on privacy, didn't report into me. We also had an environmental health and safety worker that for the US would do things like OSHA and workers' comp and employee safety, also carved out. If this were a smaller company, that privacy lawyer, that privacy work, and that environmental health and safety work probably would have fallen to one of the people that I supervised. So a lot of times it depends on how big the company is. But those are some of the breakout areas that you would think about. And then, the other ways the other corporate lawyers were organized, we would assign, we'll call them general counsels to the various divisions. So, you would have a product line that sold to the military. We would have a military general counsel that would have several people under him or her. And then you would have a commercial lawyer. We were fortunate enough and big enough to have an antitrust lawyer in-house. That's not something you see at every company.
okay, thank you.
Yeah, I was the antitrust lawyer.
Yeah, exactly.
And
Right.
I just had one rule. Anytime somebody says let's, just leave the room. Anything else?
Yeah, question about especially one of the last challenge and the first challenge that you mentioned about being in-house lawyers, which is letting the employee know that you're not representing them, but that you're representing actually the organization, the corporation. And I know courts have developed like different criteria to determine like when, especially the attorney-client privilege, like regards the corporation or when it does instead regard the employee. And I know that one of these is the substance of the conversation. And so my question is, especially being a labor and employment lawyer, how can you like draw that line between being a personal like topic that regards the employee or a general?
So it really comes into play a lot, and it is a big issue, and the law has flipped a little bit, like you said, on some of it when you're doing investigations. So if you are the person as the attorney conducting the investigation, there are things where you need to be very clear as to, this is an attorney-client privilege conversation, or maybe it's not. And you tell them, I don't represent you and I'm doing the investigation. So there's, I won't call it a script, but there are words that you would use during those investigations, depending on whether you wanted it to be privileged or whether it wasn't going to be privileged.
But you also wanted to have the opportunity to decide later. So the script would go something like, I'm a lawyer for the company. I'm here to conduct an investigation into X. You need to understand that the company views this conversation as protected by the attorney-client privilege, but the company is the holder of that privilege and may decide to waive that privilege, including giving everything you tell me to the authorities.
Yes.
And the person does not like grasp your concept, it does not grasp despite the script, despite the clearness. And then that's where the problems arises. And that's why, because maybe the other party could just decide to switch and talk about something that is only personal to you. So how do you do that? Like, are you allowed to record that conversation?
We typically didn't do any recording.
No, we didn't.
But once you give the explanation that Neil gave and they open up, it's fair game, right?
Okay.
Yeah, they choose. I think the other side of that is you got to make very clear to them that if it's an attorney-client privilege conversation, it is the company's, and if they run off and tell 6 different people what we talked about, that's not going to help keep the privilege, right? So they have to be instructed very clearly on that aspect too.
In your experience, did they ever follow that advice? That last part of don't tell
I
everyone
won't
else?
ever speak, but I done.
Did they sometimes not follow that
Sometimes they
advice?
did not follow that advice. Yeah.
I mean, yeah, sometimes you would even use that knowledge that they were going to go out and talk to send messages. You know, I would actually, I remember one investigation where I protected the whistleblower by having them sit in my outer room as if they were going to be interviewed next when I had the biggest gossip in the department being interviewed before them. So that they would come out, John would see the whistleblower sitting there, obviously about to get their time with me doing the investigation. So clearly that couldn't have been the whistleblower. So, you know, sometimes you use these internal dynamics, and this is where knowing your customer, knowing your client,
Yes.
knowing the company you're working in and who does what and how they do it, it's the value, a lot of the value that in-house counsel brings is knowing the company. And so the lawyers that want to go in-house and hope nobody ever calls, you know, it's A, it's not going to happen. B, it's not the job.
Yeah.
So you were talking about, I'm sorry, I said it was the last question, but I got one more. Sounds like you did a fair amount of travel in the role.
Yeah, it was, and that was fun actually, because if you're working at, you know, a regional U.S. law firm doing labor and employment work, you don't get to do a lot of international work. But I've dealt with, you know, union campaigns in Thailand. I've had tribunals in the UK. We've had several plants in Italy that we've had, you know, union negotiations. And while you don't bring that expertise to the matter, you do bring that ability to, you mentioned, interpret the law for both sides, right? You can help the outside counsel or the HR person in Italy understand why their manager who sits in the US doesn't really understand what's going on and why we can't do what we need to be doing. You can be that, you know, middle person that is really helpful.
Yeah.
But yeah, I've been to Brazil and various places all over the world. It's been a wonderful experience at GE.
Yeah, when you get the person that says, "But I don't want to talk to the German Works Council," you'd be like, "Well,
Well,
we're talking
we're
to
talking
them
to them.
because
Yes,
that's the
yes.
way this
They
works."
they can stop this. Yes. Yeah.
Okay.
You
Thanks
got one?
again.
I had a
You had a question. I'm so sorry.
Outside counsel, and you mentioned that you had trouble with flat fees, and especially with the beauty contests that come with them. And you mentioned that you vet firms. I was curious as to what factors go into how you vet those firms, getting to that beauty pageant stage.
So a lot of times it's, I'll call it word of mouth.
Okay.
So people that have worked with particular lawyers or people who have worked with particular firms.
Okay.
If you've worked in the industry long enough, you mentioned the names, the names, there are probably 5 or 6 labor and employment boutique firms that are across the US that you know are good firms and can do
I
it.
see.
Um,
Does that apply for international?
It is harder internationally, to be
Okay.
honest with you. It is tougher. I found it hard to. There are some U.S. firms that have relationships with international firms, and you could use that to help vet. I mentioned that I had been in Brazil. We had a significant matter in Brazil, and we needed a major law firm to help us through it. So we word of mouth, but we had them do they call them dog and pony shows, right? Talking about their experience, you know, telling us why they should be the people we selected, and we went from there.
Okay.
Yeah.
Well,
When you're in those, you have the guys come in and ladies. I'm from the Midwest again, so I say guys as a gender neutral term. I'll someday learn to stop that. You have them come in and say things like, "We were rated #1 in chambers," and you'd be like, "Don't tell me that." I mean, you can tell me that all you want, but
I want to hear what cases you worked on. Yeah,
Okay.
and what results you get. Yeah.
Right. What have you done?
Yeah.
That's like what I'm doing,
Prior.
And,
not how much did you advertise?
and I've called up other people in the, other in-house lawyers that I know, said, so-and-so has said they worked for you. What'd you think? Kind of approach.
Okay.
Anyone else?
Okay, I think we've about covered it. Darryl, thank you again for your time and all of the wisdom you've shared with us today.